What's up, guys? It's the Armed Educator here. Today we're going to be talking about one of my favorite Supreme Court cases, which is District of Columbia v. Heller. Now, I'm not going to be doing a full review on the case, but I am going to be focusing on one section of the opinion written by the late and great Antonin Scalia that gets taken out of context quite often. Scalia wrote, "Like most rights, the Second Amendment is not unlimited. It is not a right to keep and carry any weapon whatsoever, in any manner whatsoever, and for whatever purpose." That sounds really bad if you're a pro-Second Amendment advocate like myself. And it's also music to your ears if you're an anti-gunner. Even the likes of David Hogg has quoted this portion of Heller. The reality of the situation is that Scalia is being grossly taken out of context. So today, I want to take some time to discuss what firearm regulations are presumed to be lawful. The first thing I want to do is read the portion of the opinion that is being cited. Luckily for all of us, finding the opinion is as easy as a Google search. Just type in DC v. Heller PDF and click the first result. The quote that I read earlier is either found in the syllabus of the opinion or in the actual opinion itself. The syllabus portion of an opinion contains short summaries of the major positions found in the actual opinion and is written by the reporter of decisions. The quote found in the syllabus reads, "Like most rights, the Second Amendment right is not unlimited. It is not a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose. For example, concealed weapon prohibitions have been upheld under the amendment or state analogs." The court's opinion should not be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. Miller's holding that the sorts of weapons protected are those in common use at the time find support in the historical tradition of prohibiting the carrying of dangerous and unusual weapons. The actual opinion written by Scalia reads like this: "Like most rights, the right secured by the Second Amendment is not unlimited. From Blackstone through the 19th century cases, commentators and courts routinely explain that the right was not a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose." For example, the majority of 19th century courts to consider the question held that prohibitions on carrying concealed weapons were lawful under the Second Amendment or state analogs. Although we do not undertake an exhaustive historical analysis today of the full scope of the Second Amendment, nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. We also recognize another important limitation on the right to keep and carry arms. Miller said, as we have explained, that the sorts of weapons protected were those in common use at the time. We think that limitation is fairly supported by the historical tradition of prohibiting the carrying of dangerous and unusual weapons. I'm just going to go ahead and skip the final portion. It just goes on and on about what it means for militia service and yada yada yada. I know what I just read is a lot, but I'm going to try to break it down for you guys. Basically, Scalia is saying that there are 5 types of regulations that can be presumed to be lawful under the Second Amendment. What do I mean by a regulation being lawful? The first thing we have to understand is that our Constitution is the supreme law of the land. In other words, it's the law that our lawmakers must follow when making laws. In other words, lawception. As John Marshall said in Marbury versus Madison, the first time the Supreme Court ever practiced judicial review, a law repugnant to the Constitution is void. In order for Scalia to determine what regulations are presumed to be lawful, he looked through centuries of laws and legal precedent and determined that only a handful of regulations were actually passed that were upheld under Second Amendment scrutiny. As some of you may know, the Supreme Court's holding in New York State Rifle and Pistol Association versus Bruin determined that in order to justify firearm regulation, the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearm regulation. I'll discuss more on that later. The first regulations presumed to be lawful are those involving concealed carry. Scalia states that there is a historical tradition around regulating this, which is entirely true. Scalia cites 2 cases in the opinion, State v. Chandler, and Nunn v. State. State v. Chandler involved a man shooting another man while carrying a concealed weapon in Louisiana in 1848. The case worked its way up to appeals courts until it was decided in 1850 by the Louisiana Supreme Court. Louisiana's law against concealing a firearm was in question, to which the court said, "This law became absolutely necessary to counteract a vicious state of society growing out of the habit of carrying concealed weapons, and to prevent bloodshed and assassinations committed upon unsuspecting persons. It interfered with no man's right to carry arms, to use its words, in full open view, which places men upon an equality. This is the right guaranteed by the Constitution of the United States, and which is calculated to incite men to a manly and noble defense of themselves, if necessary, and of their country, without any tendency to secret advantages and unmanly assassinations." You heard that right, folks. It was considered unmanly and downright cowardly to carry a firearm concealed. Nunn v. State, on the other hand, involved a man who was arrested for carrying a handgun in Georgia in 1837, months after a complete ban on concealed carry was implemented. It too worked its way up in state appeals courts until 1846, when the Georgia Supreme Court said, "We are of the opinion, then, that so far as the Act of 1837 seeks to suppress the practice of carrying certain weapons secretly, that it is valid, inasmuch as it does not deprive the citizen of his natural right of self-defense, or of his constitutional right to keep and bear arms, but that so much of it as contains a prohibition against bearing arms openly is in conflict with the Constitution and void, and that, as the defendant has been indicted and convicted for carrying a pistol without charging that it was done in a concealed manner, under that portion of the statute which entirely forbids its use, the judgment of the court below must be reversed and the proceedings quashed." Basically, since Georgia's law prohibited concealed carry and open carry, the law is ordered unconstitutional. The court did note that if the law only prohibited concealed carry, then it would have been okay. Also, you might have noticed the mention of a natural right to self-defense. It's almost as if Scalia didn't make up the right to self-defense like the anti-gun lobby says, but hey, that's a topic for another video. Both State v. Chandler and Nunn v. State demonstrate that society at large associated carrying a firearm covertly with criminal activity or intent. Scalia makes it very clear in the opinion that the Second Amendment protects an individual right to possess a firearm and to use that arm for traditionally lawful purposes. Since concealed carry wasn't considered something you would do for traditionally lawful purposes, regulations against it were considered lawful. Obviously, public opinion around concealed carry has changed, which is why we're seeing more and more states remove their restrictions for concealed carry altogether. Let's go to the next regulation presumed to be lawful, which are prohibitions on the possession of firearms by felons and the mentally ill. Now, I don't feel the need to explain this one as much since it's something that people already understand and kind of accept. Though I will say the scope of which convicted felons should be barred from firearm ownership might be a topic more broadly covered in U.S. v. Rahimi, which will be argued next year. What do you guys think? Should nonviolent felons be prohibited from owning firearms? What about people who smoke marijuana? Let me know down in the comments. Of course, when I get information on the Rahimi case or the proceedings start to, proceed, I might make a video on that as well. Basically, these types of regulations can be seen as lawful because they are consistent with the Due Process Clause in the 14th Amendment. Basically, you can't lose a right unless due process occurs first. In the case of felons, their due process was their trial. As far as the mentally ill, we have adjudication processes to determine who is and who is not mentally fit to own firearms. This satisfies the Due Process Clause as well. The next type of regulation presumed to be lawful are laws forbidding the carrying of firearms in sensitive places such as schools and government buildings. Scalia didn't cite any previous cases to back up this claim, but the Bruin opinion does go further into detail. Justice Thomas states in Bruin, although the historical record yields relatively few 18th and 19th century sensitive places where weapons were altogether prohibited, e.g. legislative assemblies, polling places, and courthouses, we are also aware of no disputes regarding the lawfulness of such prohibitions. We therefore can assume it's settled that these locations were sensitive places where arms carrying could be prohibited consistent with the Second Amendment, and courts can use analogies to those historical regulations of sensitive places to determine that modern regulations prohibiting the carry of arms in new and analogous sensitive places are constitutionally permissible. Thomas also cites a historical inquiry article called The Sensitive Places Doctrine, Locational Limits on the Right to Bear Arms, which was published in 2018. The article combs through laws as early as 1313 England all the way to the post-Heller era. A commonality found in all these laws were that these sensitive places were buildings or enclosed areas where armed security or additional policing was already provided by the state or the property owner. Essentially, if a law restricting the carrying of arms were to be permissible, additional and adequate security should be provided. If the security isn't provided, there's no reason to restrict the carrying of arms. The fourth type of regulation presumed to be lawful are laws imposing conditions and qualifications on the commercial sale of arms. Now, arguably, these laws could be considered justified under the Commerce Clause found in Article 1, Section 8 of the Constitution. Once again, Scalia didn't go into heavy detail on the historical precedent of this type of regulation, and not many opinions since have decided to go further into detail in regard to what this portion actually means. So in my perspective, as long as regulations of the sale of arms doesn't restrict the individual right of firearm ownership, it can be assumed to be permissible. For example, when people buy guns from a dealer, they're required to perform a background check. These background checks typically don't take long, about 15-20 minutes tops. But when you start to add in waiting periods, extortionary taxes, or insurance requirements on firearm sales, that's when you could presume that the commercial regulation infringes on the individual right. Discretion on whether or not the commercial regulation infringes on the individual right is thus granted to the judge reviewing the case. There wasn't a real tangible standard for how to evaluate the constitutionality of the law until the Bruin decision. As you might remember from earlier, the standard is now to demonstrate that the regulation is consistent with the nation's historical tradition of firearm regulation. If the commercial regulation is outside the tradition, it gets the boot. The fifth type of regulation presumed to be lawful are prohibitions on the carrying of dangerous and unusual weapons. Scalia discusses U.S. v. Miller a lot in this opinion, and that is no exception here. I would like to make a video on that case. If y'all want a video on U.S. v. Miller, go ahead and like and subscribe. Anyway, Miller discusses that the militia is comprised of all males physically capable of acting in concert for the common defense, and when called for service were expected to appear bearing arms supplied by themselves and of the kind in common use at the time. Basically, if a gun wasn't particularly common and was dangerous, it could be heavily regulated and restricted. Take the Davy Crockett weapon system, for example. This gun fires a nuclear projectile. Since this weapon is both unusual and extremely dangerous, it could be presumed that regulation on it could be constitutional. Scalia also talks a lot about militia service, but again, I want to save that for a future video. Some things I want to point out. Scalia makes no mention of magazine limits, bans on common weapon platforms, insurance requirement, permit to purchase requirements, or insert your common sense gun regulation here. I get it. Anti-gunners want to do something about gun violence, and I'm all for trying to prevent tragedies. But if you want a law that is designed to prevent crime, go ahead and lay them on the table. I just have 3 criteria. The law must be constitutional. The law must be enforceable. And the law must be effective. If these criteria are not met, go back to the drawing board. Well, I hope you guys enjoyed this video. It took a lot of research and time to gather all the sources and read through them all. But if you like this content, please be sure to like and subscribe. Share these videos with your friends and family and keep them updated on the fight for your gun rights. Anyways, I'll see you guys in the next video. Until then, stay armed, stay educated.